How is this constitutional challenge likely to play out? Well, for more, I'm joined by Eric Adams. He teaches constitutional law at the University of Alberta. Thanks so much for chatting with us today, Eric.
My pleasure.
So what do you think about this step that Saskatchewan has taken?
Well, I think it's the culmination of a long political campaign against the carbon tax, and we shouldn't be too surprised that we've ended up in the courts because really, since the leadership race and before it, Scott Moe has been saying he would take this course of action, that he would challenge the constitutionality of the federal carbon tax, and that's what we've seen from the Premier today.
Can you explain more about the case that Saskatchewan is making that the federal law doesn't treat all provinces equally?
Well, what the type of case is called a reference case. And in that reference case power, a government is able to ask a question to its Court of Appeal and ask about the constitutionality of a piece of legislation. In this case, it's not a piece of Saskatchewan legislation, but the federal carbon tax. And what Saskatchewan is saying is that law is unconstitutional because it is beyond the powers of the federal government, number one. And number two, maybe the more interesting argument is the one you just mentioned, which is that it's an unconstitutional act because it treats different provinces differently depending on whether or not the province in question has a similar carbon tax to the one envisioned by the federal legislation. That, Saskatchewan says, is treating provinces differently one from the other, and that, Saskatchewan says, is unconstitutional.
How valid are those arguments likely to be?
Well, it's a novel argument, and it's not one that we've seen previously very often, if ever, in Canadian case law. So they're advancing a fairly novel claim in trying to win this case. It's hard for me to think that is a winning argument in these circumstances. There are lots of reasons why a diverse federation might be treated differently in the context of a single piece of federal legislation. So it's a speculative argument, it's a novel argument. It's going to try and push the court into new territory. And anytime that's the case, you're probably fighting an uphill battle.
Well, the Premier said he expected others to intervene in the case. So who might he think will join in?
Well, certainly the fellow provinces will be thinking about whether or not they want a piece of this action. The problem is that most provinces support the carbon tax as it's been envisioned by the federal government. The real opponents tend to be the parties in opposition currently. So it remains to be seen who exactly will want a place at the table. I certainly think some provinces are likely to step forward and want to intervene. So there may be a number of voices that are part of this case when it's eventually heard.
Now, the Premier said that Saskatchewan's plan to reduce emissions is just as good, if not better, at reducing emissions than a carbon tax. Will you think that will matter to the court?
Not particularly. The courts have tried to draw a fairly stark line between political and policy questions on the one hand and constitutional ones on the other. So if Saskatchewan has a good plan, a better plan, a worse plan, all of it is irrelevant from the point of constitutional law. The only question that the Saskatchewan Court of Appeal will focus on is not does Saskatchewan have a better idea, but rather is the federal law as proposed by the federal government within its constitutional powers. Whatever Saskatchewan says or does about its own carbon plan is, I think, mostly irrelevant.
All right, well, thank you so much for giving us this insight tonight, Eric.
My pleasure.